I will now talk about what happened in our proceedings against the VLSB in the Supreme Court and how we figured out Justice Gorton's improper coordination with the VLSB in the malicious actions that they took against us. Essentially, even before I'd set up the firm, I'd come to the attention of the LSB because of the complaints that we were making. I had companies that were involved in litigation extensively, and when lawyers acting on the other side were committing breaches of the uniform law, it was a policy that we would meticulously document those contraventions and make complaints to the LSB. Again, I was interested in developing conceptual frameworks to hold public authorities to account. So the LSB was getting annoyed. It understood that I would continue doing this forever unless something were to change. I was spending a fortune on external lawyers at the time, and the problem was that I was still writing everything that I wanted them to do. The process was very inefficient and unnecessarily expensive. I had started working with Peter Kennedy, who was the founding partner at Matrix. He was helping me set up my own firm, initially through in-house lawyers and then registering it as an ILP. Took us a while to achieve the setup, and the efforts were impeded by the COVID-19 outbreak as well. The other aspect of the work that we were doing was getting the lawyers to generate templates for everything that they were doing, for every possible scenario of contentious activity that the businesses could conceivably get into. This was the only way I could implement a standardized process. During the pandemic, one of my businesses had disputes with 3 people out of over 1,000 contracts that it had that year. And these people, each of them was from a different state. A current affair wanted to sensationalize the thing, and they did an episode about it. Because the core dispute was very boring, they sought to sensationalize the matter by bringing my name into it and talking about the fact that I have a lot of litigation on. Then they tried to make a big deal out of the fact that the businesses had contracted sole practitioners to work as general counsel. This was done under a dedicated corporate entity that would then invoice the other entities for the services of these lawyers. The uniform law specifically states that if an entity is only providing services to related entities, it cannot even register as a law firm. It's not even eligible to register as a law firm because all your lawyers are basically corporate lawyers. Their practicing certificates are corporate certificates. What the current affair idiot tried to do was to allege that the entity that was billing the other entities for the services was a fake law firm because it was never registered to practice. The lawyers who were working had practicing certificates. They had their own businesses. They had been contracted by this entity as a billing arrangement. So their billing would be consolidated in one entity, and that entity would then dispense the bills to the various entities depending on their consumption. Now, he tried to misrepresent that. What he tried to imply was that because I had been responsible for approving the templates that had been created, even where the lawyers were writing to the different parties, it was basically me writing in the name of the lawyer. Then he tried to blur the line and imply that I was using fake lawyer names. What was actually happening is that I was overseeing the work of the lawyers minutely, checking things and making sure that what they were doing was right. I tried to use as much standardization as possible. So he tried to misrepresent that as if I was doing that without the consent or knowledge of those lawyers. The LSB obviously would have known better. That's how they use Gordon Cooper, basically, without any instrument of delegation or anything. Now, the Howard Bowles idiot, the moment he heard these allegations, without even checking, without speaking with us, he immediately commented and said, this is a serious matter, we will investigate. Now, I was already setting up a business to sue government entities, and I had a fair amount of knowledge of the administrative law provisions that applied in these cases by then. So the first thing that I decided to do was sue the VLSB for breach of the public sector communication guidelines in this matter, because they could have only commented if it was a public interest matter. For that, they were required to conduct some preliminary investigation before they could know that. This was the time when the setting up of the law firm was being finalized, and a person called Ronald Gordon was initially recruited as the principal solicitor. He had misrepresented himself as, an administrative law guy, and that he was very interested in learning and blah, blah, blah. He basically wanted a cushy thing where he bossed other people around. That wasn't going to work with me. The first thing he was involved in was actually suing the LSB or sending letters of demand to them and a concerns notice. The second thing was the defamation matter against a current affair. He had even briefed barristers to commence the proceedings in the federal court. A couple of months pass by. He's not doing well. I literally have to draft every document that he was supposed to draft from scratch to show him how things are done. It's really not sustainable. I have a chat with him, and basically the first week he stayed in the office until 11. After that, 2 weeks later, he's going back home at 4:45, and I used to basically live at the office. Now, he's really bad. Also, he doesn't want to learn. Whereas the representations that he had made to me before getting employed were that, one, he had a working knowledge of those areas, and two, that he would really invest himself in learning about these things, because the whole point was to create a very technically adept firm that focused on administrative law and suing government bodies. It was clear that it's unworkable and he's not going to make an effort. I told him that I was going to get a replacement, but I expected him to cooperate until then. Otherwise, I would sue him until he was destroyed or every court had rejected me. He got really scared. The next day, he came into the office at 7 a.m., stole some files and gave them to the current affair guy. He was caught on camera while doing that. At the time, we had, on average, 3 other lawyers, depending on who had been fired that day. One of those lawyers had been exclusively recruited for cost-related matters. He had applied to us through Indeed. This is Alan McGregor. Alan was 70-something at the time, and he had applied to us for a junior lawyer's position. He'd made 2 applications, one for a junior lawyer, one for a paralegal. He had a principal certificate. He didn't have any work. We decided to use him purely for the assessment of costs in the matters we were involved in. The idea was that if the matters went to the cost court, because of his experience, he'd be able to deal with them on his own. This way we could focus the other resources purely on litigation. When Ronald Gordon did what he did, we saw him on camera stealing the files and so on. He was fired that day. Then there was the problem of who's going to be the principal solicitor. Alan had a principal practicing certificate. He was appointed as the principal solicitor that day. And then we started looking for a replacement for Ronald Gordon. Now, that's the time when we were involved in a proceeding that came before Gorton. This was a dispute about the office premises that the firm and a related entity were renting. Basically, the owner of the property took the view that because under a corporate lease agreement, there wasn't any right to have the place functional in every respect. It was discretionary, but he conducted repairs on time. So I stopped paying him. I did that to create inconvenience, so he would be pressured into conducting the repairs quickly. Normally, what I would do is pay them just enough so they don't meet the technical requirements for issuing the notice to vacate, or pay them right on the day they issue the notice to vacate, just the arrears, and then drag it out until they conduct the repairs. So that's what we were doing. We complied with every technicality. What the asshole did was he started charging us a fee for issuing the notices, which was completely unlawful because it's a penalty that people cannot charge. But what he started doing was when we would pay him the fee, he would say that's basically the arrears that you owed us from issuing the notice. So now you're in deficit. Based on that, he tried to get us to vacate the premises. The VCAT member was an idiot and didn't understand the concept of penalties. Ronald Gordon, by the way, appeared in the matter and argued the penalty thing. This was the first hearing, and then there was another hearing. By then, he had left. So I did the second hearing. The member forgot some things that had been agreed between the parties during the first hearing. So I produced a transcript of that first hearing, and the barrister on the other side said that the member should not look at the transcript because I caused the hearing to be illegally recorded and then produced a transcript of that recording. Basically, it's the product of, a criminal offense. He said that purely on the basis that the transcript carried the logo of the firm. He had misrepresented an agreement that had been achieved between the parties during the first hearing. And the member didn't remember it. I was specifically calling it into evidence, but because of that, she didn't look at it. Now, the VCAT does not release transcripts. They only release audio recordings that you then have to transcribe through different parties, or you can do it yourself. We had given the other side a copy of the transcript 4 weeks before the hearing, and the audio recording as well. Also, the member had herself approved the release of the audio recording, which they're required to do. Despite all of that, she instinctively accepted his submission. We lodged an injunctive relief application. Gorton was the duty judge. It came before him. The hearing took place at around 9 at night. And I presented the case that evening. Alan McGregor introduced me as the client. And he said that he wasn't familiar with the case. I had presented the case at VCAT, and he's recently taken over from Ronald Gordon. He didn't have enough time to apprise himself of the details, so that's why I'm presenting the case. Gordon was super cool with it. He gave us an injunction. This was done on the basis that the proceeding hadn't started yet, but there's a procedure pursuant to which the court can hear an application as if the originating documents had been filed, grant an injunction, and then give a limited time within which the originating documents should be filed. We had 4 days to lodge the originating documents. In the interim, the other side filed an affidavit which set out the various disputes that I had previously had with VCAT members and the critical comments that they had made about me. Now, I'm famously very direct with judges. It's about the democratic process, everybody being equal and so on. These people put all of those things before Gorton. Gorton got prejudiced. What they were saying is that I should be prevented from presenting the case on behalf of the company because it's up to the court's discretion. The moment they filed those documents, I made an application to exclude the evidence because it was unfairly prejudicial. It was tendency evidence. There's a very high requirement for the introduction of tendency evidence under the Uniform Evidence Act. Basically, the criterion is that you can only introduce tendency evidence if there is no other explanation that's reasonably available to explain the conduct of the person. It's a very high threshold. So I argued that before Gorton. Gorton basically said that you're not a party to the proceeding and your credibility is not necessarily in question. They're only attacking your position as well, in the context of whether or not I should give you the indulgence to represent the company. He said because he has unfettered discretion in that sense, the Evidence Act effectively would not apply because it's outside the scope of what it was conceived to do. I tried to explain to him that firstly, I may have to give evidence in the proceeding, and then he would have basically assessed my credibility in an adverse way. Secondly, it was common ground that it was hearsay because it wasn't part of the judgment. I had skirmishes with these idiots at VCAT where I was criticizing them for not knowing the law and they were basically talking back at me. And they had introduced that into evidence. There was no basis upon which it could be accepted as a record of orders that were made or whatever because it was not reflected in the orders. And so it was purely hearsay. Those people were not coming to give evidence. I had the right to present contrary evidence. So Gorton did not allow me to present contrary evidence because it would have taken too long. He allowed them to rely on hearsay evidence because there is a rule, a section of the Evidence Act, which says that in interlocutory proceedings, you can rely on hearsay evidence if there's a lot of conditions, none of which was met. He allowed them to rely on that only in relation to the question of whether or not he would give me the indulgence of representing the company. He did that whilst accepting that there was no basis to rely upon that as an accurate account of what had happened, and on the basis that he accepted that I had a perfectly good explanation to explain the events in a way that was at worst neutral to me, in the sense that I was not at fault. He said that the only thing he was considering, though, was that it could not be said about me that I had represented companies without incident. Literally, it's in his written fucking judgment. That's how stupid he is. He said it was only relevant because the inference he drew from it was that it could not be said about me that I had represented the companies without incident. The other thing he was doing was that he was stopping me from suing the lawyer on the other side. His rationale was that ultimately it was the member who made the order. You don't need to sue the guy to reverse the order. You can just say that the member made a mistake, blah, blah, blah. Why do you want to, destroy someone's career? He understood why I was doing it. He accepted that the other guy had, in effect, breached the uniform law. In fact, he had even admitted that. During the hearing, I put him on notice that I would sue him. By the end of the hearing, the solicitor for the other side had sent me an apology letter and a letter to the tribunal apologizing for the allegation. It was clear admission. Gorton noted that. He said, you have every right to be offended, blah, blah, blah. This is not how things are done. But anyway, you should just go for the conventional relief. When I said no, he couldn't stop me from doing that. Then he said, I wouldn't be comfortable having a non-lawyer make the allegation against a lawyer. This is all on transcript. Then he was like, a lawyer should be making these allegations if they need to be made. Ultimately, I rebuked him for being an idiot. Gorton was upset about it. He made an adverse cost order, even though I won the application, just to express his dissatisfaction. The second proceeding that Alan McGregor was involved in was a proceeding in the federal court before Justice Wheelahan. That's how we realized Alan was senile. He would appear in the hearings and then basically lose track of what had happened previously. He would prepare for the hearings, go through the documents, but be completely blank. This happened a few times, and Justice Wheelahan was getting very impatient with it. There had been delays in the lodgement of documents because of Ronald Gordon's shenanigans. At one point, Justice Wheelahan made an order requiring the principal solicitor to affirm an affidavit about the steps he had been taking to comply with the orders, because he had missed a few of those. So I called Alan in to instruct him about the affidavit. As the client, I told him that he should note in the affidavit that the client thinks that in making the order, the judge failed to consider that in detailing the steps the lawyer was taking, he would inevitably be forced to reveal or disclose legally privileged information. Therefore, he had acted contrary to his requirements to uphold the substantive law in relation to client legal privilege. So that was the part of the affidavit critical of Justice Wheelahan. Alan was given the draft of that affidavit to affirm it. A paralegal had drafted up for him based on the discussion that we had when he was in office. Ronald Gordon had started talking to Alan McGregor to influence him because I had a proceeding live against him in the Supreme Court for breach of confidence and so on. So he was trying to influence Alan and was obviously senile and getting affected. So he wrote to the judge's chambers to check if the orders requiring an affidavit to be filed were actually made. He wanted a copy of the orders from the judge's chambers without telling us and provided the draft affidavit. Wheelahan provided that to the LSB in the sense that, the lawyer is not able to function. The same day, Alice Duggan appointed Damien Naylon to conduct an audit into the affairs of People's Shop. The problem was that the way in which Wheelahan had done it was not a formal complaint. The uniform law only allows them to appoint an auditor in case of a firm that does not operate a trust account if there is a complaint, either a consumer complaint or a disciplinary complaint. This was on the 9th of November. We made a formal complaint against Allen to the LSB on the 16th of November. They acknowledge it on the 17th of November. On the 18th of November, they write to Allen and tell him that the auditor has been appointed. They imply to him that he's been appointed because of the complaint that we made against Allen. And that if he doesn't cooperate, then he loses his license because of the complaint that we're making. That's how they get him to cooperate with them without telling us. Then they call us about the complaint we made against Allen. Maria's coordinating with them. They asked us how we're managing the affairs of the firm in the absence of Allen and so on and so forth. What they're trying to do is bring in the angle that you don't have a principal solicitor, therefore we are going to conduct an audit, or you need to stop functioning. All this while we're conducting recruitment. We had agreed with the LSB that by the 3rd of December, we should be able to find a replacement to carry on the thing. It's important to note here that the law only says that you cannot operate without a principal solicitor being employed. Allen was still employed, so it's not that we didn't have a principal solicitor. The principal solicitor we agreed to hire on the 3rd of December was someone who had stopped practicing while he was overseas. He had had some issues with the LSB in the past, but he hadn't told us about them because he didn't think they were relevant. When he sought to renew his practicing certificate on the 3rd of December, they refused to renew it. Then they wrote to us and said that because you don't have a principal solicitor, we've appointed Damien Nailon. Damien Nailon was actually appointed on the 9th of November. They tell Allen on the 18th that he had been appointed because we had made a complaint against him. They tell us that he's appointed because we don't have a principal solicitor. They haven't given anyone the notice of appointment yet. All this while, emails are being exchanged every day between us and the LSB. It's getting increasingly contentious. We're gearing towards suing them because they're putting a lot of pressure and saying, give us all the files. Give us the details of every case you have, every barrister you've instructed, and every person who's worked for you. We don't even know what the scope of the audit is yet. No details have been provided. Our position was that we suspected Ronald Gordon had leaked information that I was developing a case against Howard Bowles and everything we were doing against the LSB, which, by the way, they confirmed later on. What they were trying to do is understand what evidence we had against them. We're still recruiting. We needed more than one lawyer anyway. That's when Peter Ansel and I got in touch. We needed urgent representation. Peter appeared for us in the federal court on the 2nd of December. We told him about a situation we had hired. A principal solicitor whose practicing certificate was not being renewed immediately. We needed someone to continue operating the firm. Peter agreed to be the principal solicitor until we could find a permanent replacement. He was appointed on the 10th of December. Now the LSB had a problem because they could no longer use that excuse to do the audit. On the 13th of December, we wrote an aggressive letter to Alice Duggan, the person responsible for dealing with our case. We tell her that we've appointed Peter Ansel as the principal solicitor. We ask for the notice of appointment. We ask for all the facts pursuant to which he has been appointed and so on. We put them on notice that we will sue them for misfeasance in public office and abuse of authority if we are not satisfied. This is on the 13th of December. On the 14th of December, they wrote to Justice Wheelahan and said that they need a complaint or a determination from him based on which they can take action. Wheelahan forwards that letter to me and tells them that if they want to raise issues about misconduct and so on, they need to do it in open court. Now, they're fucked also because I know now that they don't have anything because they wrote to Wheelahan right after I threatened them. At that point, they contact Gorton and Forbes the two Supreme Court judges, before whom Allen had appeared. Before Forbes, it was injunctive relief in relation to Ronald Gordon, Sam Cucchiara, and a current affair about the publication of privileged material. Now, I had represented myself, and Allen had represented another director of the company, Maria. Allen's involvement was limited to saying, "Good afternoon, Your Honor," and at the end, I endorse Mr. Cook's submissions. That's all he was doing. No one could complain about his conduct. Now, the LSB had already told us that they had written to all the courts as early as April to tell them that I was producing the documents the lawyers were purportedly producing. And in their view, the applications for the lawyers' obligations under the Civil Procedure Act. We knew then that they would have communicated. Our proceeding against the LSP was actually allocated to Justice Gorton, who was orthodox and very reluctant to make declarations against government officers, but he's a proper judge. He was the head of the list. He knew the law, as ideologically opposed to the aggressive declaratory relief that I was seeking, as His Honor may have been. I knew that he would not break the law to proactively pursue his ideology. When I say break the law, I mean he made a lot of legal errors, some of which he conceded, but it wasn't driven by malice. Even where I know that he would have known better, I know how much he struggled and to resist what I was asking him, and it wasn't easy. There wasn't active malice. He made plenty of determinations against the LSP. He had no problems putting all the allegations against the LSP in his judgment and setting out what needed to be done in the matter. Stephen Walters, he told me that his brother is best friends with Rapke. I didn't know that. I didn't know whether there was a conflict, but I trusted His Honor to be upfront if there had been a conflict. The problem was that he was due for retirement in August 2023. There were 4 proceedings that we had against the LSP and Victoria Police that went to him at the same time. He prioritized the Victoria Police ones until the day of the hearing, which was on the 17th of August. This was the hearing against the LSP, the first substantive one. We didn't know who the judge was. We kept writing to the list, asking for the name of the judge. They wouldn't tell us. Several hours before the hearing, told us that it's Gorton. If I knew it was Gorton, I would have applied for his recusal. We'd already waited almost a year for the matter to come on. The LSP has pulled every fucking trick that they can to get the prothonotary to delay the listing of the matter. Then Peter and Lulu are very anxious to have the matter move forward. I am too, but I will make every application that should be made. They were reluctant to start making recusal applications against Gorton based on previous experiences. They thought he was a judge and wouldn't be a complete scoundrel. So they wanted us to try with him first and let him prove himself one way or the other, and then we proceed. When the first hearing before Judicial Registrar was being listed, we had filed a summons several months before the hearing. The LSB filed summons 2 or 3 days before the hearing. They did not serve the summons on us. Their summons said that our proceedings should be dismissed without identifying why, except that they thought that it was scandalous that we were accusing the LSB officials of engaging in a perversion of the course of justice, because they got the Channel 9 cameraman into the office and recorded the contents of the files and so on. Everything factual. When the hearing comes on, I oppose the listing of their summons because it's obviously an attempt to disrupt the progression of the matter. The first thing we wanted in terms of the resolution of the matter was the determination of 3 separate questions in the proceeding, which had to do with the appointments of the 3 people, Nailon, Rapke, and Gordon Cooper. What they wanted was a summary dismissal of the entire proceeding, which was much wider. We would have had to cover ground for the whole proceeding, which would have meant that the 3 questions could not be prioritized as separate questions. It would have taken too long. We wanted quick resolution because Peter's practicing certificate had been retroactively cancelled after he had started the proceeding. I opposed the listing of their summons because it had not been served, and there's an explicit rule that you can't hear summons that have not been served. The fact is that a judicial registrar has no authority to supersede the rules through his decision. Only a judge can do that. I opposed the hearing of their summons because they had not been served. The judicial registrar asked them if they had been served, and they implied that they had been served. The barrister said he would have to check and get instructions. The judicial registrar said, I can either adjourn the matter to next month, and we have been waiting for this desperately, or I can make orders on the basis that they have served the summons with liberty to apply. So I appealed his decision because it was fundamentally wrong and in denial of procedural fairness. The first day, the issue that Gorton had to decide was whether the judicial registrar had made a mistake. Right from the start, he says, well, they did the wrong thing. They should have served the summons. And yes, it denied you procedural fairness and blah, blah, blah. But then he says, you should have put up with it. Because ultimately, what difference would it have made? He says, their matter should have been listed as well. We're like, you just said that we were denied procedural fairness. He says, yeah, but, big deal. It was just a summary dismissal application. Everybody has a right to blah, blah, blah. And I said, no, they don't, because if I had been on notice of it, I would have filed a summons that the court declared to be an abusive process. Then, Gordon starts rolling his eyes that I'm being overly fucking technical, like I always am. He makes indemnity orders against us because we had the audacity to be overly technical about procedural fairness requirements. And that if we had just put up with it, then ultimately nothing would have changed, even though they did the wrong thing. He wanted to send a signal that being overly legalistic is, in his opinion, wrong. He was carrying on a gripe from the last fucking time that I had scolded him. That's how we start off. And then it basically continues. On the 5th of December, 2023, I told him that I had discovered evidence through subpoenas and other proceedings that they've been writing to all the judges. And they have admitted that they had written to everybody. He was on the list. The evidence had been discovered by subpoena in the other proceeding. After the evidence had been discovered, there hadn't been a next hearing in that matter. The documents had not entered the public domain because they hadn't been discussed in an open hearing yet. We sought release from the Harmon undertaking. The Supreme Court can give release on behalf of subordinate courts. So it didn't matter that it was in a different proceeding because he could have given us release. By the way, the other side had not put any conditions on the user. It was clear that there wouldn't be any problem. So we sought release from the Harmon undertaking. The first thing Gorton asks is, do these documents implicate me? Literally. He says, do you say that these documents show that I have done something wrong, that I have communicated with the fucking LSB? I'm like, not directly, but also I can't talk about it because if I talk about it, then I'm breaching the Harmon undertaking and it's technically contempt of court. He says, okay, but you still confirm that I'm not directly implicated in this, right? We were also bringing an application for his recusal at the time on the basis that he may have had communication with the LSB. So he was like, can you prove that I was talking to them through these documents? We asked him to confirm whether or not he had engaged in communication with the LSB about the complaint because we had a clear idea that he had. And he didn't tell us. We thought he would at least put it in his reasons. Now, I'm using this opportunity to mercilessly attack the LSB. It was communication between LSB and Victoria Police. We had subpoenaed the police to get it. The LSB still had those documents. And I kept taunting them that, the LSB could just release them. They had a barrister, Marie Norton, who offered to produce the documents to the court on LSB's behalf. Norton did this, by the way, on her own discretion because of her obligations as an officer of the court, which I was constantly reminding her of. Gorton criticizes her. Does not let her put the documents in. She says, okay, I'll seek instructions. Then Mazaris tells her not to. The excuse Gorton uses at the time is that it would waste the court's time in going through all of these documents. We instantly knew that something was up because why would Gorton stop her from releasing the documents of the LSB's communication with the court? In his reasons, instead of answering the question about whether or not he had had any communication with the VLSB, Gorton notes, to my credit, I made it very clear that I didn't have any evidence of Gorton communicating with the VLSB. That's what he says, instead of clarifying whether or not he had actually had any communication with the VLSB. Now, we know that he's crooked, and we have to basically prove it, but we have to set him up on a number of things first before we can do that. So we start subpoenaing the VLSB for all their correspondence with the courts, and especially any complaints. The point is that under the uniform law, Peter and the firm had the right to be advised of every complaint made against them. Gorton rules that it's irrelevant who made the complaint, because we're basically arguing that the LSB has taken the wrong decisions. That's not the only thing we were arguing. We were arguing a bunch of other things. So first, he decides that in a judicial review proceeding, he shouldn't decide all the other things, purely out of discretion. All the other things should be dealt with in a tort law proceeding or something like that, not here. Then he says that now that we are only arguing that they made the wrong decisions, we should be focused on the mistakes that they've made. It doesn't matter who incited them. Ultimately, it was their responsibility not to be incited. On that basis, he rejects all the subpoenas that we wanted the court to issue. That's completely unlawful. The law about subpoenas is that even if the evidence they produce is not admissible or relevant, you can still subpoena it, so long as you can present an apparent benefit that it can give you. The most conventional way of doing it is to attack the credibility of the witness. If we could say that we can use the subpoena to demonstrate that this person at the LSB had an improper motive to make decisions against us because this judge was influencing him or whatever, then we can still use them. So now Gorton rules that we can't test the credibility of the witnesses. Literally, he ruled that we cannot attack the credibility of Amnesty in relation to the notices that he issued. Because in his view, Amnesty's credibility is not a fact in the proceeding. I didn't even know what the proceeding was about anymore. We were alleging that they had done something wrong, which Gorton had a responsibility to assess. We positioned everything from an angle of discovery of evidence. I had to pull a lot of maneuvers to argue that. Every time I would successfully make an argument, he would cut short the proceeding so as to exclude the discovery of evidence. All this while, what he kept doing was making indemnity cost orders against us on lump sum, enforceable immediately. So the LSB could then charge us hundreds of thousands of dollars, like close to $500,000 they've already been claiming. Then, as was clearly the fucking intention, they issued bankruptcy notices against all three of us. They issued 9 bankruptcy notices about the same orders. They first issued the notice via email. Then they issued the same notice via post. The service via post said, you now have 21 days. The email had been sent 10 days earlier. Okay? So we applied to set aside the notices in accordance with the date by the post. They came back and argued that we had committed an act of bankruptcy because we didn't apply in accordance with the email that was sent 10 days earlier, even though the service by post said that we now have 21 days to set aside these notices. The same fucking notices. That's the proceeding before the federal court. I was actually pretty excited about the proceedings because I knew I could subpoena the correspondence between Gorton and the LSB, because we were going to attack the decisions as fraudulently obtained. One of the clearest things was that he had prevented me from cross-examining Amnesty and ruled that the credibility of the witness was not something that was an issue in the proceeding, so we could not cross-examine him on credibility. What Amnesty had literally done was produce a certificate, signed it himself, saying that he thinks that there is a proper basis to suspect that the firm is breaking the law and Peter Ansel is not doing his job. Therefore, he appoints this investigator to investigate the matter. Then he affirmed an affidavit saying that there was a certificate on the record of LSB in relation to the firm and Peter Ansel. And on the basis of that certificate, he had taken the decision to do something. So he fucking produces a certificate, exhibits that as documentary evidence. The certificate doesn't allude to anything else except his own reasonable suspicion. Determines that because he's simply producing documentary evidence, his credibility is not an issue. I'm saying that he's the maker of the fucking certificate. Then I cite to him the sections of the Crimes Act and all the other things Anstey could have breached in falsely certifying the document and so on. Gorton was literally guarding Anstey with his life. The moment we would ask something, he'd say, I object to that. Immediately, the LSB counsel is not taking objections. Like some of the things he's fucking shocked about. I pointed out that McAuliffe, the counsel for the LSB, was not raising these objections. I told him that I would take all of these interactions, put them through a software program to show that he was acting fraudulently, and his pathetic desperation would be demonstrated as a matter of objective fact. He didn't even hear me. That's how nervous or anxious he was. I said, fuck, I don't know how many times during that hearing. He didn't even bat an eyelid about that. So at the next hearing, I came determined to hold him to account. I accused him of being a scoundrel and a scourge on honest judges everywhere. Then I told him that he had no option but to charge me with contempt or determine that I had made those allegations on proper basis, because it's not about his honor, it's about the integrity of the court system. He said, well, so what you're saying is that it's that easy to get rid of a judge because when I charge you with contempt, a different judge takes over and so on. I reminded him that criminal contempt can incur an imprisonment of up to 2 years or whatever. I don't have a criminal record. The minor assault thing would be a much lower penalty than criminal contempt. So it was completely ridiculous to say that we would commit a higher crime to get rid of him. I told him that if someone wants to really get rid of a judge, they can, if they're willing to commit crime. This is, by the way, on the transcript. He didn't have a response to that, obviously. I repeated the allegation at the time that he had done all of that to protect them because he had been conspiring with them, and he must produce the documents regarding his communication with the LSB. Again, refused to address that in the reasons. Didn't even mention that I had alleged that he had been conspiring with them. After he rules, the decision not to renew Peter's certificate had operational effect. He's now going to assess whether or not it was lawful. He didn't even explain how that would reconcile with the operation of Section 463 of the Uniform Law, which basically says that if a decision is unlawful, it's ineffective as of the date on which it was made. So his position is that until he determines that it's unlawful, it's taken to be effective. And when he determines, or if he determines it's unlawful, then it retroactively applies, which is completely fucking stupid. Because in the interim, he's determined that Peter has committed a criminal offense in effect. I mean, because this is a civil proceeding and it's just declarations, so it's not a criminal offense in the standard sense that we'd have a criminal record, but he's granted injunctions on that basis, on that finding of fact. And it's on the civil standard, not on the criminal standard. Anyway, we applied to the federal court to subpoena the correspondence between the two bodies. They opposed the subpoena, so we filed an FOI so we could use it in support of our subpoena application because they were going to object to it. And we would say that, you see, there's communication and that obviously cannot be good because he's a judge in the matter. Therefore, the court should release the subpoena. When we FOI'd the thing, they immediately opposed it, as I had predicted. He had been continuously asking Gorton for the correspondence. He wasn't giving it. I mean, he wasn't even responding to us. Not that he was not giving it. This had been going on for over a year. So this time we wrote to him with the LSB's FOI rejection. We copied the Attorney General and the Chief Justice. He wrote back and said he's not going to entertain any further communication on the subject anymore. Then I wrote to him and I told him that he had an obligation to provide us with the disclosure. He wasn't going to entertain any communication about this. He's also not going to give any reasons. That was a clear problem because a judge cannot refuse reasons. It's a jurisdictional error. It's a fundamental attribute of judicial power that reasons are given. The LSB has been writing to the court in relation to every other proceeding that we have. They're fucked in those proceedings because some of those proceedings relate to subpoena applications that they had improperly resisted. And then I started the proceeding here. But at the same time, I kept on fighting in the same proceeding for the discovery of those subpoenas because interlocutory decisions don't have an issue stopper. And I succeeded. The magistrates or, in some case, judges, when they saw the communication, thought it was obviously unlawful and was arguably criminally inciting the police. And they released it. So we've already won those proceedings because they've not challenged the decisions in those cases. And we're only seeking review of their decision to oppose the disclosure of documents which they could not have lawfully opposed pursuant to the objectives of the uniform law. Secondly, Rapke was my lawyer, or at least former lawyer, after he ceased to act on behalf of the firm, and he was opposing the subpoenas after the ceasing to act was filed. Those are the declarations we're seeking. They're already fucked in those proceedings. They're writing to the judges in those proceedings saying that they expect us to be bankrupted, so the proceedings should be stayed. That's the contempt. Now, this is about the IBAC complaint. So, Dene had basically ruled that IBAC fucked up in not investigating the matter. He did that in response to the summary dismissal application. He said that the only thing that's uncertain right now is the audio recording of the police that we have that implicates them in serious crimes. Therefore, he cannot conclusively decide the matter. But that's the only uncertainty because the IBAC had not accepted the authenticity of the recording, even though the police had in the other proceedings. By the way, to conveniently take away that point, IBAC then admitted the veracity of the evidence. After IBAC admitted the veracity of the evidence, we had what? The IBAC also had the clever idea of revisiting its decision. Because it was made on jurisdictional error, they could just reopen the complaint. But in reopening the complaint, it was conceding that it was a jurisdictional error. That's the only circumstance in which it can revisit the decision. This is laid out in a High Court authority called Minister of Immigration versus Bhardwaj. The IBAC then brought an application that because what we were seeking was that they investigate the police. Now that they've started investigating the police pursuant to our complaint, the proceeding has no benefit and should not be decided and dismissed without a decision being made. Gorton spoke to the judge who presided over the matter to accept that application. It was Justice Quigley. She got caught. She admitted it during the proceeding because she was doing some very stupid things in relation to interlocutory matters during the same hearing. I put her on notice of the unlawfulness of what she was doing. I told her what had happened with Gorton. And then she said she had sought instructions from him in relation to how to deal with me. She repeated the steps that he had taken. When I raised the recusal application, she said that she would not decide the recusal application on the spot, as she's required to. She made substantive decisions in the matter about interlocutory applications, but deferred the hearing of the recusal application to a later stage, which she would decide on papers. This is basically what Gorton had started doing towards the end. She confirmed that Gorton had told her to act that way because of his experience with us. The orders were basically the same as Gorton had made. Even the timeframes that he had given were the same. Obviously, we wanted Gorton's communication there as well because there's a conflict there. Our position is that because all these matters involve the LSB conspiring with the police in different capacities, we're subpoenaing all their communication with the courts and the police in all the proceedings. Gorton has to obstruct that, otherwise he gets exposed. Therefore, he incited the judge to determined that there was no point in deciding the application anymore because the IBAC had already acted upon our thing. It would just be a waste of time. Then she came up with a clever ground of her own, which was that it may even create problems for the IBAC's investigation because she may have to make findings of criminal conduct on the part of Victoria Police while the IBAC is still investigating them. IBAC hadn't even fucking raised that ground. She ruled against Ganey. She clarified that she was allowed to rule against Ganey because this was only a preliminary thing, and she doesn't think that there's any point. She also ruled that, in her view, the only reasonable explanation why we're doing this is to embarrass the IBAC so we can publish about it online. And she considers that to be an abusive process. This is obviously Gorton inciting her because she was only there for 2 days and she knew everything about everything. That's basically the crux of the matter in relation to the proceedings against the LSB. Now, what we're alleging in terms of contempt are the following things. One, they seized our files from the firm and then gave them to the police. We have discovered correspondence between police officers. So the police officer who had accompanied the LSB on the day that they took over, he wrote an email to the informant in the proceeding, and he'd said that the LSB had seized all my case files in that matter. And if he wants a copy of all the files that I've been maintaining in the proceeding against the police, then I should contact Howard Bowles. The police officer was Michael Howard. So the IBAC first refused to investigate. Then, after Ganey made the decision that they have fucked up in not investigating the police, they reopened the investigation into the LSB. They told me during mediation that the conduct of the LSB was just despicable and they were going to go after it. But then Gorton came in and made all sorts of decisions. And he said, what's the point in a judicial review court making all these tort law sort of declarations against the LSB? He was not going to do any of that. That emboldened the IBAC because they know that the moment they investigate the LSB, I'm going to sue them for misfeasance by admission, which is what I'm doing in relation to the Victoria Police matter. So they're fucked if they do, they're fucked if they don't. So that's one specific charge of contempt. The second charge is in relation to pressuring Peter to sit for an examination, the purpose of which was to get access to documents that were protected by client legal privilege. Peter had told them that we had already lodged an application in the Supreme Court challenging the lawfulness of Gordon Cooper's appointment. He was the guy who had produced the notice to produce to Peter. The LSB contacted the Prothonotary, told them that Peter's practicing certificate had been suspended. So the application should not be sealed by the court because one of the applicants was a company, and under the rules, the firm cannot act without a lawyer. In rejecting the application, the Prothonotary gave reasons that Peter's practicing certificate had been suspended. Then the LSB applied to the court to say that Peter was unlawfully resisting the examination notice. Peter said that he had already lodged the proceeding. The judge asked the other side if that was true. They said they have no idea, even though Peter had given them a copy of the originating motion that he had lodged, based on which they had contacted the Prothonotary. And the judge then proceeded on the basis that there was no evidence that Peter had lodged the proceeding. He made orders that Peter comply with the notice to produce about the privileged material. And they disrupted or interfered in the commencement of the proceedings. The Prothonotary later admitted he was at fault and sealed the document after their proceeding had been commenced and the judge was prevented from knowing about our proceeding. The third charge is in relation to writing to judges in proceedings. They recruited a corrupt judge to prevent the disclosure of documents and make all sorts of exorbitant cost orders on lump sum basis enforceable immediately for interlocutory matters where we've not done anything wrong. He's basically made those orders to allow them to issue these bankruptcy notices Those are the 3 contempt charges that we are filing against different officers in the board. Besides that, we're going to seek declaratory relief against a number of people, including Joanne Jenkins and Fiona McLean. We'll rely on some of the matters that Thomas has raised. What the LSB does in particular is weaponize prejudicial allegations very effectively. So they will try to introduce horrible accusations against the people. They have themselves manufactured those allegations to prejudice the mind of the member or whoever has to decide into thinking that there is a high possibility or a reasonable possibility that this lawyer will do something improper, and then it's going to come back and bite me in the ass. That's a big part of their modus operandi. The other thing it does is, if the member is already on their side, it gives them some sort of justification by repeating those allegations in their judgment. That's the pattern of conduct they engage in terms of interfering in the judicial process. The proceeding will make other judges and members aware of it. I am going to bring a declaratory relief motion against the Attorney General because I think that they have an obligation to either charge me with contempt or join themselves in the proceeding to seek Gorton's recusal. Otherwise, they're scandalizing the affairs. I haven't done that yet because I haven't applied to join them in Gorton's proceeding. If they don't take up the opportunity, then I will seek a declaration against them. Nothing I'm doing about this is subtle. I'm going to sue the IBAC for dismissing my complaint against Gorton. Under the IBAC Act, the exception for corruption allegations against the judge is if they've made decisions within the realm of error of law, then the IBAC is not to investigate them in that respect. But that's not what the allegation was. The allegation was that he had communicated with the LSB and then sat on the proceeding. He has admitted it. I wrote to him and said that I'm going to be more abusive to him because I have a duty to force him to respond. It would be even worse if he hadn't communicated and not clarified. Also, I told him that more than anything else, the good thing about his getting caught is that I don't have to pretend to be respectful to him in court because he's a piece of shit. The IBAC was required to investigate whether they had communicated, and it has subpoena powers of its own. I don't have to give them evidence of culpability when I make a complaint. So long as it's made on reasonable basis and there is a preliminary basis to investigate, they have to investigate and discover the facts on their own. Because the LSB know that they have fucked up, that's why they never raised any objection to the recusal applications. All this while, we were wondering why they were never, Gorton invites them to oppose the recusal applications, and irrespective of how abusive I've gotten, they've never once raised any objection to the recusal application. It's because they know they will get into trouble. They have been communicating with Gorton. And right now, they're basically hiding behind him in the sense that if he decides that the correspondence should not be released, then he's a judge. There's been a judicial determination, effectively. They're playing it very fucking safe, never directly opposing the recusal application. But when it comes to cost orders, they're always there to seek indemnity costs on that basis. What they also do is raise those matters in front of other judges to imply that we're committing contempt of court. And they never even oppose the recusal applications. All of these things can be used to demonstrate what's called consciousness of guilt, the Jones v. Dunkel inferences that can be drawn about their behavior. It puts them under the obligation to deny it explicitly on affidavit. The joke in all of this is that I could have punched Gorton in the face and he would have said that he fell on my fist, face first, just to prevent me from being charged with contempt. I'm going to put in an affidavit in the proceeding that LSB has been screwing over a lot of people, and I have agreed to help all of them so long as they all give their honest opinion about Gorton. When I have enough time, I will hire people to stand outside the fucking State Library of Victoria, play clips about Gorton's proceedings, and tick boxes about whether he's a scandalous and corrupt judge or not. I have already advertised all of that to Gorton. As far as I'm concerned, first of all, sub judice would not apply in this matter, or scandalization would not apply because it's honest and it's sincere and it's factual. I've also advertised all of these things. And he has ruled that I genuinely believe that he's a scoundrel. He's already ruled that, so I cannot be charged with contempt in this matter. If you genuinely believe that a judge is a scoundrel or a traitor or whatever, then under the Charter of Human Rights and Responsibilities, you have a right to express your conscience unless a law explicitly prohibits it. The High Court has found that people have a right to be abusive because it's not just about the words, it's about what the connotation is. It's an expression of anger. People have a right to express themselves in whatever manner that is lawful. It's an artistic expression of people's rage against the government. It's a necessary element of the democratic checks and balances that the Constitution puts on the government. Now, Gorton is gone underground. He's not scheduling any further hearings in the matter. In the recent decision, Tricario, that came out 2-3 days ago, Justice Gray did what we've been arguing should be done and set aside the decision to suspend the practicing certificate. It was enforceable right from the beginning. Anstey was the witness again. The judge wasn't conflicted. So his credibility was very much a question. He was required to produce all the documents that he had relied on in making the decision he had made, which Gorton prevented us from doing. Based on those documents, the judge found that Anstey did not have enough to form a reasonable suspicion in relation to the matters he had a suspicion about. What the VLSB did with Tricario was in essence the same. They received notification that she had been charged without checking the evidence that the police had, without even getting her to respond to the allegations. They never specified how long the suspension will operate or whether she can apply again. Nothing. They just suspended it. They keep people in the fucking limbo. That's what the judge found to be wrong. In fact, one of the things that the judge pointed out in the recent decision is that a preemptive disciplinary step against someone getting the practicing certificate is only justified where there is a likelihood that the same conduct will reoccur. Justice Gray found that because what she was charged with was such a peculiar thing, the possibility of reoffending was very low. In Peter's case, they haven't even charged him with anything. They didn't suspend his license. They're just not letting him renew it. They haven't told him of the period for which he cannot renew it. They're just not processing his application. What they have to demonstrate is that the possibility of the person doing the same thing, if their practicing certificate is renewed, is so high that it justifies the preemptive stay of the thing while the matter is being decided. There is no basis in law for them to do that. I'm going to end with this quote from Blatch versus Archer. All evidence is to be weighed according to the proof which it was in the power of one side to have produced and in the power of the other side to have contradicted. This is an ancient principle of how the court should draw inferences from Blatch versus Archer, 1774. It's a British authority of Chief Justice Lord Mansfield. We're inviting people to contact us about their fights with the VLSB. It will help everybody. Therefore, it's in everybody's interest that they come forward and give evidence.
Can I just add something further?
Yeah, sure.
Just general comments. It's clear from what's happened in my matter and clear from reading material in other matters that the LSB, as you said, have to fast and loose and indeed act dishonestly. The issue that Shavesh mentioned about contacting the respondent directly was an extraordinary thing for them to have done, to deliberately delay our proceedings. So their MO is pretty clear, is to subjugate and hurt you so badly financially, etc., that they make new to you in relation to what you can do and fight back. The other point I would just like to make in relation to my involvement with Shabesh over the last 2 years, I can guarantee you that I've never seen any person put so much effort into what he does, the hours he spends, the minute detail he goes into is quite extraordinary. The fact that he's picked up a number of these matters, especially we talk about the magistrate's court matters, in which he managed to have all the charges dropped and argued those cases succinctly before the court was exceptional. Indeed, he had a number of magistrates in all of the fact that they knew more about the law than they did, and the fact that he's able to argue very coherently and with good legal basis the matters before the Supreme Court, again, is testament to the amount of work that he puts into this. And I can't stress that more than that. It's exceptional in that regard.